Hey there, I'm estate planning attorney Paul Rabalais, and in this video, we're going to talk about how the now 1-year-old Secure Act impacts your estate planning. All right, so first thing I want to do is I want to thank all of you who have watched and subscribed. I realized that I just passed the 1.2 million views threshold, and I just passed the 14,000 subscriber threshold. Thank you so much. It means so much to me that you're watching and commenting and subscribing. So if you haven't subscribed, make sure you do so. Just click the subscribe button. It doesn't cost you anything, and now you won't miss anything as we move forward. So all that being said, let's go back to the Secure Act. The Secure Act took effect on January 1st of 2020, and it did many things, but one of the most talked about things that the Secure Act did was it eliminated the stretch required distributions over the lifetime of the beneficiary option. And let's discuss how that impacts your estate planning. The best way to describe the impact is, let me give you an example. So let's say dad is single and he has a teenager. We'll call the teenager Junior. Dad's net worth is roughly $1 million, and roughly half of that is in dad's IRA. Also could be in his 401k or some other similar retirement account. The main thing on dad's mind is if dad dies, dad doesn't want Junior to get his $1 million net worth in a lump sum. In fact, he doesn't. Currently, Junior is the designated beneficiary on dad's $500,000 retirement account, and dad doesn't even want Junior to immediately be able to get all of that. So dad would much prefer to see, if dad dies, payments made to Junior over a long time so that kind of number one, Junior doesn't blow $1 million. Number two, Junior doesn't blow off college. And number three, Junior will receive payments later in life when hopefully Junior has grown up and become more mature and responsible. But the problem is we have this 1-year-old Secure Act, which requires that if dad dies, that Junior get distributions from dad's IRA, and it all must be taken out of dad's IRA and distributed to Junior no later than 10 years after dad dies or when Junior turns 28. Because if Junior is under 18 when dad dies, that 10-year period doesn't start until Junior turns 18. So what should dad's strategy be? And this has come across kind of my office, my desk, a few times over the last year since the Secure Act was created. And so we've had to be a little creative in helping people who want to make sure that their beneficiaries don't get too much money too fast, and those people want to set things up so that their beneficiaries and heirs can benefit from inheritance over a long period of time. So what should dad do under those circumstances where he has a $1 million estate, half of it, $500,000 in an IRA, and dad has, let's call it an 18-year-old, and dad doesn't want the 18-year-old to get $1 million. He doesn't want the 18-year-old Junior to get $500,000 because Junior would if he was the beneficiary of the IRA. So what should dad do? Well, here's a strategy that maybe dad would consider. Let's take the IRA and let's leave it to what I'll call a see-through conduit trust, and dad will name some other company or friend or relative other than Junior as the trustee of that trust. And he'll establish that trust in a manner that the trustee can determine when Junior gets the distributions from the IRA, as long as it is all distributed prior to the Secure Act's required minimum distribution period, which is the later of 10 years after dad dies or when Junior turns 28. So when it's set up that way, when dad dies, instead of 18-year-old Junior getting a chunk, $500,000, have to pay tax on that in all of 1 year, would cause him to go on the highest tax rate, and then Junior would likely blow some or all of it, and it'd be poof gone. So instead of that, maybe when dad dies, if it goes to one of these see-through conduit trustees, the trustee can dole out maybe distributions over a 10-year period. And if it was $500,000, I realize it's going to be invested and it may grow, but let's say that trustee were to distribute maybe annual $50,000 distributions over a 10-year period. That would cover Junior's, college expenses and allow him to get additional distributions as he starts in his career or professional life or whatever that might be. So that's a way that to maximize the use of Dad's IRA. But then Dad had another $500,000. Remember, he had $1 million estate and only half of it was the IRA. He had another $500,000, and maybe that was Dad's home, Dad's other investment accounts that were not his retirement accounts. Maybe he had bank accounts and other assets. What should Dad do with that? Well, if Dad knows that Junior's got to get the $500,000 from the IRA over a 10-year period, starting immediately when Dad dies, Dad ought to provide that the remaining estate assets or living trust assets, depending upon how Dad set it up, would not be distributed at all until at least 10 years after Dad died. Because Junior's going to get that $500,000 over a 10-year period after Dad dies. Well, then maybe Junior shouldn't get any of the estate assets until beyond that 10-year period. So in Dad's will, in Dad's living trust, he says, none of my estate assets are going to be distributed to Junior until after 10 years after my death. So that might be the best case scenario to prolong Junior benefiting from Dad's $1 million estate. Allow Junior to get the required distributions over a 10-year period at a trustee's discretion. Trustee may not give anything for 5 years. Trustee may give it all just before the 10-year deadline. But the trustee who best understands Junior needs gets to make those decisions. And then the other assets are paid out after the 10-year period. That would allow Dad's estate to really benefit Junior for a long period of time. Okay, one other strategy that I think is really important. Some people, and now I'm talking about grandparents, for example, some grandparents want to leave assets both to their children and their grandchildren. Some people just say, I want it all to go to my kids. But some people say, no, I want to provide for my kids and I want to provide for my grandkids. Some people say, let's leave half of my estate to my kids and let's leave half of my estate to my grandkids. They might say, I have 2 kids, I have 7 grandkids. So my kids collectively will split half. They'll each get a quarter, and then my 7 grandkids will split the other half. Individually, they'll get less than my kids, but collectively my grandkids will get half. So, and let's say the grandparent has a $2 million estate. He's got $1 million in his IRA, and he's got $1 million of other estate assets. What should he do? Well, the Secure Act has caused us to really flip how things should go. So what he might have done prior to the Secure Act is left his IRA to his grandkids, perhaps either to them or to a trust for them. If that trust was done the right way, distributions could be made from that inherited IRA over the grandchildren's life expectancy. That option no longer exists with the Secure Act. So now what Grandpa could do is he should consider leaving his $1 million IRA to his children. I realize they'll have to pay income tax, so net after tax they'll get less, and maybe he can kind of compensate in other areas. But he should leave his IRA to his children. If he has children and grandchildren, his children are probably 40 years old, give or take. And so they're probably, established in life and able to make wise decisions on what to do with the money, even if they have to take distributions within 10 years after grandfather's death. So leave the IRA to the children who are a little more mature, and there's no fear of them just blowing the money because they have to take the distributions within 10 years after grandfather's death. And then leave the other $1 million estate assets in a trust for the grandkids. And there's no limit on how long the grandfather could provide for distributions to be made to those grandchildren from that trust, which receives assets other than the IRA assets. So it's a mouthful there, but with the new Secure Act, which requires when non-spouses are beneficiaries, requires that the distributions be made from that inherited IRA and tax be paid within a 10-year period after the IRA owner's death. There's some new thinking on when you're leaving assets to children and grandchildren, really who should be the beneficiary of those assets and whether you should attempt to leave those assets to a trust for the benefit of children or grandchildren to maximize the use of those IRA assets over that 10-year period after the IRA owner dies. Okay, so there's a couple of thinking points there about how to best utilize your IRA and your beneficiary designations as part of an overall estate planning program strategy to maximize what you leave for your family, minimize government interference, minimize the risk that immature people may blow an inheritance, and just overall keep assets in the bloodlines for as long as possible. Okay, hope that helps. We'll see you next time.